In this lecture, we would like to discuss one of the most landmark judgment delivered by the Supreme Court in 1991 relating to the case Smt.Gracy vs. State of Kerala, wherein particularly in the part of introduction and regarding the very facts related to this case which was falling under prevention of illicit traffics on Narcotic Drugs and Psychotropic Substances Act 1988. So, here the petitioner, Smt.Gracy, was the mother of the detainee Noor alias Babu, and in regarding that she filed a writ petition under Article 32 challenging the very detention. So the legal issues involved Article 22 Clause 5 of the Constitution of India and the very sections of the Prevention of Illicit Traffic on Narcotic Drugs and Psychotropic Substances Act 1988, particularly she challenged Section 3, Section 9F and Section 10, Clause 2 of the Act. So, then we will discuss about the petitioner's arguments and the contentions of the respondent. Besides that, we will discuss some important precedents cited by the Apex Court, and exactly we would like to discuss the 7 most important precedents cited by the Apex Court. And finally, we will discuss the legal reasoning, the judgment delivered by the Apex Court, and the very implications of the judgment. So, here the petitioner, Smt.Gracy, was the mother of the detainee Noor alias Babu, invoked Article 32 of the Constitution to challenge two particular orders. So the first order is regarding the detention order, which was dated 25th January 1990, which was issued under Section 3 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, and the second order that was challenged under Article 32 was regarding the central government's confirmation order, which was dated 24th April 1990, made under Section 9F and Section 10, Clause 2 of the Act, directing the very detention for 2 years, which would effect from 30th January 1990. As Noor and Elias, the son of the petitioner, was arrested on 19 October 1989 in Kerala on the very allegations of illicit cultivation of ganja under the Narcotic Drugs and Psychotropic Substances Act 1985. Although bail was initially refused, conditional bail was later granted, fearing that release and bail would facilitate further illicit cultivation. The detaining authority issued the preventive detention order. The order informed Noor of his right to make representation to the detaining authority, the central government, and the Central Advisory Board. The central government referred the case to the advisory board, and during the pendency of this reference, the detainee submitted single representation addressed only to the advisory board. The board considered the reference and the representation opined that there was sufficient cause for detention and forwarded its opinion and the entire record to the central government. Relying on that opinion and expressed why the advisory board, without an independent assessment of the representation made by Noor, the central government confirmed the detention for 2 years. So now we'll discuss those legal issues involved. So the very question arises whether Article 22, Clause 5 of the Constitution of India imposes on the central government a mandatory independent duty to consider a detainee's representation even when that representation was addressed solely to the advisory board. Further, the question raised if such an independent duty exists, whether the central government's failure to discharge it invalidates both the original detention order by the Kerala government and the very subsequent confirmation by the central government. So, now we'll discuss about the very contentions presented by the petitioner's counsel. So, the counsel for the petitioner presented that Article 22, Clause 5 guarantees not only the right to submit a representation but also a correlative duty on the detaining authority, the central government, to consider it promptly and independently of the advisory board. Further, the central government's opinion, as it is regarding omission to evaluate the detainee's representation, constitutes a procedural lapse rendering the detention illegal. In regard to the very contention and arguments of the petitioner's counsel, the respondent, the central government of the Union Government of India's argument that there was no separate obligation arose because the detainee's representation was addressed exclusively to the advisory board and never to the central government. Further, consequently, the question of consideration by the central government would only arise when a representation is duly made to the central government. So, in connection to the very arguments tendered by the petitioner's counsel and the contentions responded by the respondent, the apex court cited certain precedents as it was they were decided by the apex courts. In regarding to those precedents cited, we would like to discuss the past one. Sheikh Abdullah vs. State of West Bengal in 1969, where Supreme Court in particularly emphasized the very doctrine of dual obligation as it was provided under Section 22, Clause 5 of the Constitution. Article 22, Clause 5 of the Constitution of India. And the second most important landmark judgment cited by the apex court was relating to Shyamal Chakravarti versus Commissioner of Police, and it was decided by the apex court in 1969, and that was relating to governmental representation by the detainee. And the third most important landmark judgment cited by the apex court as it was decided by the apex court itself in 1970, and that was Pankaj Kumar Chakrabarti vs. State of West Bengal, where again Article 22, Clause 5 of the Constitution was cited relating to doctrine of dual obligation as it is provided under Article 22, Clause 5 of the Constitution. Further, the apex court in the judgment of 1991 also referred to the precedent that was decided by the apex court in 1972 relating to B. Sundar Rao versus State of Odisha, and it was relating to the role of the government or the union government, central government, and the advisory board regarding the very application tendered by the detainee as it is provided relating to dual obligation under Article 22, Clause 5 of the Constitution of India. Further, in 1975 decision by the apex court in relating to the landmark judgment John Martin vs. State of West Bengal was also referred by the apex court relating to the very role and responsibility of the union government or central government and the advisory board in cases of detention regarding the Preventive Detention Act and also relating to all the special laws as the Prevention of Illicit Traffics on Narcotic Drugs and Psychotropic Substances Act 1988. Further, the apex court made reference to one of its judgment delivered in the year 1975 relating to Shekhawat versus State of West Bengal regarding the very scrutinization of the representation given by the detainee to either to the central government or to the advisory board as provided under Article 22, Clause 5 of the Constitution of India. And in the last important landmark judgment cited by the apex court in this important landmark judgment, Smt.Gracy vs. State of Kerala in 1991, the apex court referred one of its judgments delivered in the year 1975 relating to Haradan Shah versus State of West Bengal, where the apex court laid down strict compliance of the provisions of Article 22, Clause 5. So now we'll discuss about the very reasoning, that the legal reasoning that was examined and analyzed by the apex court. So the apex court, in particularly Justice J.S. Burma, began by stating the constitutional mandate articulated in under Article 22, Clause 5 not only grants the right to representation but also creates a dual, non-derogable obligation. One is that the advisory board must consider the representation when the reference is made. And the second observation, legal reasoning, was that the detaining authority, as in case of here, the central government must independently examine and decide the representation without being influenced by the advisory board's opinion. So, in the landmark judgment, the Solicitor General of India argued that as because Noor or Alas Babu representation was addressed exclusively to the advisory board, no duty arose for the central government. The apex court rejected this as an impermissible elevation of the form over substance, emphasizing the very provisions of the Constitution of India, which provides under Article 22, Clause 5, which refers to representation against the other, without restricting the manner of address. Once a representation exists, the constitutional duty simultaneously and automatically attaches with this provision. Further, the advisory board's role is merely advisory, only the government can revoke or confer a detention order. Thus, governmental consideration is indispensable. Further, the legal reasoning made by Justice Barma that preventive detention involves a exceptional curtailment of liberty, strict, not formally strict, adherence to safeguard is quietly required. So, consequently, by failing to independently evaluate the present petitioner's representation prior to confirmation, the central government violated the very provisions of Article 22, Clause 5. This constitutional infraction vitiated both the initial detention order and of the state of Kerala and also the confirmation order of the central government, that is the Union of India. So finally the apex court held that the writ petition filed under Article 32 of the Constitution by Smt.Gracy, mother of the detainee Noor or Babu, was allowed, and the apex court quashed both the detention order issued by the state of Kerala on 25th January 1990 and the confirmation order of the central government. And finally, we would like to discuss the implications of this important landmark judgment, which was delivered in the year 1991 by the apex court regarding as the very detention order and the confirmation order both were quashed. So, it was also upheld the prevention of illicit traffics on narcotic drugs and psychotropic substances Act 1988, and the very custodial status of the detainee in connection to the bail was also another important implication. So, in this important landmark judgment, on behalf of the son of Noor alias Babu of the petitioner Smt.Gracy, regarding preventive detention under the Prevention of Illicit Traffics on Narcotic Drugs and Psychotropic Substances Act 1988 cannot continue on the basis of the quashed orders. However, the apex court clarified that the decision does not interfere with any ongoing criminal prosecution under the NDPS Act of 1985 and the amended Act of Prevention of Illicit Traffics on Narcotic Drugs and Psychotropic Substances Act 1988, or the very detainee's custodial status if the bail has been refused in those proceedings. So, in particularly regarding the very discussion relating to this landmark judgment, that is Smt.Gracy vs. State of Kerala in 1991 by the apex court, where the very detention order of the government of State of Kerala and also the very confirmation order of the central government was quashed, and in spite of that, criminal prosecution under the various provisions of the NDPS Act of 1985 and the Amendment Act of 1988, that is the Prevention of Illicit Traffics and Narcotic Drugs and Psychotropic Substances Act, would continue. And even in this particular case, relating to Smt.Gracy versus State of Kerala, as he was the petitioner, mother of the detainee Noor or alias Babu, in that particular case, the apex court held that the custodial status of the detainee would continue if the bail had been refused in those proceedings. So, hereby we conclude our lecture on this landmark judgment delivered by the apex court in the year 1991 relating to preventive detention and the very constitutional provisions as laid down under Article 22, Clause 5 of the Constitution of India, and in particularly in relation to the special law that was enacted in 1985 as the Narcotic Drug Psychotropic Substances Act, and when it was amended in the year 1988 as Prevention of Illicit Traffics on Narcotic Drugs Psychotropic Substances Act, and those very important sections relating to those acts, Section 3, Section 9, Clause F, and Section 10, Clause 2 of those acts.